So up until last Thursday, I was a partner in big law. So how many private sector lawyers are in the room? A few of you. All right. Well, so for 18 years, I was, really for 30 years, two firms in big law, and I've been in healthcare for 40 years, and I just decided, you know what, it's time to do something different. So on Friday, I officially launched Gravely, no offense. My wife says Gravely, so you're in good company. Gravely Group, which is me. and so this is my first formal appearance, and I really appreciate the opportunity to be here. As I said, I've been in healthcare for 40 years, former hospital administrator back in the day. I have a master's in hospital administration. Then for the last 30 plus years, I've been practicing healthcare law, just like many of you in the room, doing everything from soup to nuts in healthcare law. But for the last decade, I've really been focused on digital healthcare law and interoperability. And the reason for that is because one of my clients was one of the original trial implementation participants under the ONC efforts to build what is today eHealth Exchange, what then was the Nationwide Health Information Network. And I led the work group that wrote the DRSA. Most of you are probably familiar with the DRSA. It was a very early multi-party data sharing agreement, really the first of its kind. It's still around. We're actually amending it again because of the continuing evolution of the ecosystem. And so that really brought me full force into the interoperability health information exchange space. And that's really what I'm doing through Gravely Group, is really the intersection of law, policy, and strategic issues for health organizations when it comes to information and digital health. So with that very brief introduction, for those of you who haven't met, let's dive into TEFCA. But before we do that, we have to always remember that TEFCA is not the headwater. The headwater is the 21st Century Cures Act. And I'll tell you why that's super important here in a couple of minutes. But Cures was passed in November of 16, I guess, signed by President Obama in the final days of his administration in mid-December of 16. And it's really an omnibus bill. Cures does a little bit of everything. It was really a collaborative effort of the House and the Senate to address a whole bunch of issues in healthcare. Everything from FDA to emergency preparedness for the healthcare sector to our favorite topic, interoperability and health IT. And so in that part of Cures, what Congress directed ONC, Office of the National Coordinator, to do was to either develop or support, and that's important language, develop or support a trusted exchange framework that would enable data sharing. Now, this was 2016, folks. I mean, MyHIN had been around. eHealth Exchange had been around for almost 8 years at that point. There were hundreds of HIEs. And so why is Congress saying in 2016, we want you to develop or support a trust framework? Well, the short story, we could talk about this all day, the short story is Congress didn't think that what we had was working. And that's sort of a criticism of everybody in this room and everybody in the industry. Now, we don't necessarily agree with Congress, but that was their finding. They looked out over the landscape and they saw what they thought were pockets of interoperability and too much information blocking and too much competition and too much people holding data hostage for commercial purposes. That's what Congress saw. Now, whether you agree with that or not, is fine, but that's what Congress saw. And that's what led to this section of Cures. And so in response to that, and I think that foundation is really important as we look at TEFCA, in response to that, ONC then started working, and finally in January of this year, published what we all know as the TEFCA. So, of course, it stands for Trusted Exchange Framework and Common Agreement. That's a very important and. And there are really two parts of this. My friend Mark Siegel recently, retired from GE Digital Health a couple of years ago, is now a consultant. We do a lot of work together. Mark likes to talk about the TEF and the CA. And at first I thought it was weird, but actually it's a pretty darn good way of thinking about it, the TEF and the CHA. So the TEF is really the Trusted Exchange Framework part of TEFCA, and the CHA is the Common Agreement part of TEFCA. And those are related, but they are distinct, and that distinction is important, and I'm going to try to make that clear here in over the next few slides. So this is a busy slide. I'm sure you've seen this before. You probably sat in on webinars that lasted 2 or 3 hours talking basically about this slide. We're not going to do that. You'll be happy to know. But this one is very, ONC prepared this, and as far as I'm concerned, it's one of the best one-page summaries I've seen. And as you all know, the TEF, the Trusted Exchange Framework guidance that ONC put out, has a Part A and a Part B. Kind of sounds like Medicare, but Part A, Part B. And Part A, think about that really as sort of the policy framework, and Part B is more of the nuts and bolts. And we do not have time to unpack this, and I expect you're already familiar with it, but just really briefly, if you look at the Part A side of this slide, what I would ask you to really focus on, there are 6 principles of trust. Again, I think you probably know this already. The 3 that I want to call out to you this morning, number 1 is standardization. That's really that's a lightning rod, standardization. Some people are saying, well, wait a minute. Does that mean that ONC is going to adopt binding standards that tell the industry how to do things, and isn't that going to stifle innovation? The answer is we don't know if ONC is going to do that. And if they did, it probably would stifle innovation. So that's a big question mark about what, we all can get on board with standardization. I mean, I think we all would agree we could benefit from more standardization in data exchange so that there is a commonly accepted format for messages, so that, we have some rules around what should be attached to a CCD, so that you're not getting 5,000 pages of junk along with the CCD. I mean, we all know there are problems here. But on the other hand, no one's quite sure what ONC is going to do here. So that's an important one. Principle 3 around cooperation and non-discrimination is very controversial. And this goes to the heart of what ONC, or what Congress was concerned about in terms of information blocking. Now, I serve as general counsel for Healthy Way, Inc., which is a Sequoia project, and they are a 501c3 that operates the eHealth Exchange, as well as Care Equality, which is started as a vendor-led initiative. And when we wrote the Care Equality Trust Agreement, we included a non-discrimination provision in there, which was very controversial back in 2014. But now, here we see it in TEFCA, and I think most people agree that this is really the standard that we ought to be shooting for. And I think this Principle 3 is going to manifest itself through the information blocking rules that I'm going to talk about in a moment. And then the last one I want to focus on is Principle 5, access. And really, this is the one I think that focuses in on patient empowerment and putting the patient at the center of the health data ecosystem. And that concept, which has been knocked around now for probably 10 or 15 years, is actually here. It's here today. And so TEFCA is acknowledging that and elevating that to the status of one of its 6 principles of trusted exchange. And then on the Part B side, this is really, at the risk of oversimplifying, this is really about security and consistency. And I think somewhat transparency. And these are mostly technical standards. If you haven't read the guidance, you don't have to. You can read MyHIN's comments or Sequoia's comments or AHA's comments, HIM's comments. There's a lot of comments out there that are very helpful in terms of talking about what this might mean. These slides are ONC products. I'm going to move through these very quickly. And then segue into what does this probably mean for us who are in the industry. So this is ONC's vision of what the TEF will look like when it's fully implemented. And you see there are 3 main components. There's this RCE umbrella, recognized coordinated entity. You You gotta love the feds. Recognized coordinating entity. The QHIN, which is a qualified health information network, and then what they call participants, which really are HINs, health information networks, unfortunately at the bottom of the slide. And we don't have time to talk about the symbolic meaning of the way this is organized. But basically, this is the picture in ONC's mind of what they call the single on-ramp to interoperability in the country. So let's unpack really quickly. There's some really important points here about these definitions. And I only have time to just touch on a couple of highlights. I'm around all day if you want to talk about this further. So let's start at, not the bottom, but let's start at the grassroots level, which is the Health Information Network. And this is the definition of a health information network under TEFCA. And it's a three-part definition. I'm not going to read it to you because you've probably seen it before. But what's problematic about this definition is in bullets 1 and really in all 3 bullets, towards the end, you see between or among 2 or more unaffiliated individuals or entities. And I'm not savvy enough to have highlighted that. But unaffiliated, that's a key word because no one exactly knows what that means. And there have been a lot of comments from state health information exchanges and from enterprise health information exchanges that are affiliated with health systems to say, wait a minute, does that mean that we're automatically DQ'd from being a HIN under TEFCA? Because what does unaffiliated mean? It's not defined anywhere. So there's a lot of debate right now about that word in these definitions, and people are scratching their heads and saying, well, I want to be a HIN, but I'm not sure if I can be because I don't know what unaffiliated means. It could be that we'll get clarification. We're going to have some clarification from ONC about that in order for people to raise their hands and say, I want to be a HIN, and know whether they meet the criteria. So let's move on then to the next topic. And I'm sorry to be going so fast. I just want to cram your head full of as much of TEFCA as I can. Qualified HINs. And so what is a qualified HIN? Well, it's a HIN that meets other requirements. Basically think about that. And those other requirements have to do with bullet number, with sub-bullet number A, which is the connectivity broker, or really B, the connectivity broker concept. That's the key concept for a QHIN, is the connectivity broker. And basically that's a functionality that it's an RLS, a record locator service, sorry, I don't want to slip into acronyms, you know, master patient index, master person index, a record locator service, some other utility that enables query retrieve functionality in the context of a digital exchange network. And so in order to be a QHIN, you have to have that capability. You either have to own it or you have to buy it. And then there's some other requirements to be a QHIN. ONC has sort of vacillated back and forth about this requirement. The requirement of a connectivity broker, as most of you probably know, it's very query retrieve based. So the idea of having a record locator service, that's essential for document query exchange. It's not really necessary for other use cases. And if you remember Jeff's slide, which was a great slide, showing all the use cases arrayed by maturity, there's a whole lot of use cases out there beyond query retrieve. And ONC has come under some fire, maybe justifiably so, for saying your TEFCA is really obsessed with query retrieve. What about the rest of the universe? And right now, we don't really have an answer to that. And then, so lastly, the RCE, and this one is really interesting. So the TEFCA says there will be some organization that will be contracted with us, with ONC, to basically supervise this single on-ramp that we call the TEF. And the RCE will have a CA. They will create a common agreement that will then, all the QHINs will sign, and the terms will be flowed down to the HINs. So the RCE will be in charge of governance. It'll be in charge of enforcement. It'll have a contract with the federal government. And other than that, there's really not much specificity about what are the requirements, what are the obligations, what are the expectations. And so there's a lot of us that are scratching our heads. Certainly Sequoia is, I think MyHIN is, I think a lot of us are scratching our heads about, well, I mean, what is this? If we want to step up and do it, what are we taking on? What's the responsibility? What's the liability? What's the payment? This is not going to be inexpensive. So there's a lot of uncertainty right now in the industry about the RCE. So with that, I want to segue into like 3 slides, and I can't see the. I don't know if I've gotten the 5-minute hook yet or not. I want to segue into like 3 slides that bring all this concept down to like, what does this mean for those of you in the room? Whether you're a legal counsel, or whether you're a policy person, this affects every single one of us in this room for sure. And I want to talk about this within the construct of cures, because Congress said in cures that that ONC would not duplicate or disrupt existing activity. I didn't have time to put that on the slide, but that's really important because that was a mandate from Congress. And there's a lot of debate right now around what does duplicate and disrupt mean, and has ONC essentially thrown everybody out with the bathwater, and are they starting from scratch? I don't think that's true, but there's a lot of discussion about that. So as you think about the impact of TEFCA on your organizations, think about it through the lens of the congressional mandate that ONC not duplicate or disrupt existing operations. So here are my 3, what I think are the big 3 impacts of TEFCA on everyone in healthcare, certainly everyone in health information exchange. Information blocking, absolutely number 1. The changes that will be required to folks' existing data sharing agreements and policies, and I probably should add corporate structure as well. And then a new level of accountability. So let's quickly unpack these. So information blocking. As you know, the Cures Act, absolutely black and white, makes information blocking illegal. It is illegal. Now, then, of course, the question is, well, what is that? What is information blocking? And that's where we don't know, because Congress basically directs the Office of Inspector General and the ONC to promulgate regulations that tell us what information blocking is not. In other words, what is permissible. So it's like a white list. So OIG and ONC are supposed to give us the white list, and everything else is presumptively illegal under cures. We're still waiting for the white list. We've now had 2 delays from ONC and OIG. We are promised that they will be forthcoming in August or September. I was talking with my good colleague, Lindsay Austin, who's based with me in D.C. She's actually still at Troutman in the lobbying practice. We work together all the time. And she said she doesn't think that either agency is prepared for a 3rd delay. So she's thinking that we'll probably see these at the end of the summer or September. But it's hard to say, because GAO is really scrutinizing everything that comes out of Health and Human Services. And so we'll see them eventually, but I'm not sure when we'll see them. But when we do, they're going to be transformative. So that will affect everyone. OIG, most of you probably know the Office of Inspector General if you're in healthcare. Those are the guys that do the Stark and any kickback and Medicare billing. That they have a very well-oiled machine for enforcement. And most of us in healthcare, give them a wide berth. And so, years ago, before I sort of focused down on the tiny little simple field of digital health and interoperability, I did some fraud defense, and they're formidable. So the idea of the OIG being in charge of enforcing information blocking allegations, that certainly gets my attention. So I think that a lot of what people accept today as, oh, this is just the way things are done, that's not going to be permitted anymore. And I think that will be a sea change. Data sharing agreements and policies, I've already talked about unaffiliated persons and what does that mean. The TEF also kind of slaps around this notion of 2-party agreements. So remember I mentioned that the DURSA was the first of its kind multi-party agreement. And there are others of those around. But then most organizations, including Care Equality, have gone with really 2-party agreements where you've got the HIE or the supernode or the network or whatever it is, the man in the middle, having agreements with all of its parties. It's a perfectly appropriate, tried and true, standard, effective model. TEFCA sort of slaps that one around a little bit and says, we don't, two-party agreements may not pass muster. Well, that doesn't make any sense. I mean, what do they mean by that? So we're all sort of watching that one and to see what they come out with in their FOA and with a funding and opportunity announcement, and really where does the RCE go with this? And is everyone in the country going to have to restructure their agreements, which would be very inefficient? Chain of custody, Jeff did a nice job of talking about that. It's surprising how folks in the industry don't really think about this that way. They think chain of custody, they think, well, that's what we do in the ED when the police bring somebody in who's suspected of driving a vehicle under the influence, and we draw blood or we do something else, and we have a chain of custody for that vial of blood all the way through the testing process so that it's admissible in court down the road. People don't really think about chain of custody in terms of electronic health records and data, but we're going to have to start thinking about it that way. And that's really a pretty important sea change, I think. And then lastly, APIs, as Jeff was talking about the Ring of Fire upstairs, which I have to go see, where they're doing the fire pits and doing APIs. APIs are here. They've been around for a while. They're nothing new. There are hundreds of thousands of them. Now, the vendors have to accommodate them. They're everywhere. But there's still resistance to allowing a patient to say, send my records to my app. There's still resistance in the industry to that because people say, well, what if it's not your app? I mean, I want a safe harbor under HIPAA because I don't want to send that information to an app that I haven't personally verified. And I've heard from the lips of Devin McGraw when she was still at OCR, we don't care if the app is from North Korea. If the patient says send it, you send it. That's the law. And so we have a pretty seismic, budding, plates are bumping together here between the industry and OCR. And we all know what happens when plates bump together, and that's kind of where we are. And I think that TEFCA is going to flush that one out. And then lastly, a new level of accountability. Again, I've been in healthcare for 40 years. And one of my first jobs in healthcare when I was a brand new minted, Proby administrator was to develop a conventional med-mal risk management program when all the insurers pulled out of the market and our health system was self-insured. And everybody hated it because it was like Big Brother. And I have the scars to prove it. And over my career, there have been many of those, compliance. If you've been in healthcare for more than 5 years, you've been through a few of these. I sense that TEFCA is a similar type of phenomenon. There will be a new level of accountability for our industry when it comes to the data we have, the data we generate, the data we transact vis-a-vis the patient. And there's nothing wrong with that. I mean, personally, having been a patient, I actually kind of support that. However, as counsel for the industry, as a strategic advisor to the industry, as someone who's been in the industry for 40 years, it's going to change things. And it's hard to overestimate the magnitude of that. And as I said, we've gone from the jingle stage on patient-centered to where it really is a legal mandate. And this is going to occupy most of us in this room for the rest of our careers in ways that we probably cannot even imagine. So with that, let me yield the stage to my colleague, Nate, and I'm happy to, I guess we'll take questions at the end. I'll also be around, and I'm happy to chat with you today. Thank you.
Good morning. Thanks, Steve. I feel a little bit like the prognosticators at the end of an NBA season who want to do the hot takes like, oh, too early predictions for next year. Because this is still draft stage, we have yet to receive the final version of this. Who knows what's going to change in the interim based on comments. We can say that the Warriors are going to be good and LeBron's going to make the finals. So I guess that's what we can rely on. Of course, that's not that shocking of a prediction. So let's talk a little bit about how this is going to shake out in Michigan specifically. So before TEFCA, you saw Jeff's slide as an introduction. The the slide with MyHIN as the middle with those clean spokes coming out from MyHIN to various participants. And that's good, that's how we want it, but there's also somewhat of a reality too, where we recognize that these different participants within MyHIN also have their own connections that they have to contend with outside of MyHIN. When the ONC was looking at TEFCA, they surveyed 70 hospitals, and the majority of those hospitals required 3 or more connections for data sharing, and 30% of them required 5 or more. So as optimistic as we are about the data sharing scenario in Michigan, we realize that this is somewhat what it looks like, that there is this connection to MyHIN, but there are also these other connections within the industry that various healthcare providers, health plans need to account for. So once we get a final version of TEFCA and this rolls out, what is it going to look like for us? This is what we think it's going to look like. You're going to have a qualified HIN at the top that is connecting with other qualified HINs across the country. Interestingly, ONC has indicated that they envision some small number of QHINs, like dozens, not like 1 per state even, but even fewer than that. So a small number of QHINs across the country, because the logistics are going to be somewhat tricky for those QHINs to connect with each other, and the RCE that Steve talked about is going to have to manage those relationships. It's just not going to be feasible, they think, to have a high number of QHINs. So think about this. There's going to be a small number of QHINs. Those are connecting to various participants, primarily going to be health information exchanges themselves or health information networks. And then those participants are connecting to end users, which are probably what many of you are or will be. The CA, I like that. That's a good way to talk about it. The CA in the TEFCA is going to have requirements for the QHINs to abide by, but then TEFCA also requires that those QHINs roll those provisions down to their participants, and those participants in turn roll those obligations down to end users. So while there is going to be some amount of churn among QHINs getting those contracts in place between QHINs and participants, there is going to be a similar amount of churn when those participants are required to roll those terms down to end users. Once we get a final version of the regulations, we're going to have 12 months to get those changes in place. So first there has to be an RCE to get the CA. So we're still a ways out from that because we need the RCE to get the CA, then everything rolls from that. The data sharing scenarios that ONC really envisions as being primary as part of TEFCA are TPO situations, so treatment, payment, and healthcare operations, individual access, allowing an individual to access their data and direct it to a third party, public health, and then benefits determination like Social Security, disability. I just want to highlight a few changes or obligations, I guess, in the agreement that we will probably see, that ONC has already indicated we will see in the agreements that will flow down to participants as part of their obligation of participating in with a QHIN. So the participants are going to have to support these primary purposes of data sharing, those 6 that I just outlined. Again, those participants are going to roll those down to end users. We already talked about the exclusivity. Steve did a good job of talking about that. You can't discriminate as far as who you're sharing data with. QHINs can't prevent participants from participating with another QHIN if they want. Similarly, participants can't stop their end users from doing something similar. The participants are going to have an obligation of identity proofing of end users and individuals of the system. I thought another one that was very interesting was that if there is an obligation or a request for an individual to share an individual's information that requires a consent, the participant is going to have to send a copy of that consent to the QHIN as part of that. So it's not just an assertion or attestation that yes, we have appropriate consent, but that we will actually have to deliver a copy of the consent to the QHIN. again, participants are going to want to roll these down to end users. So if you're ultimately the end user, that's going to be an obligation that flows back up. We talked about information blocking as well. There's also an obligation to provide written documentation evidencing compliance with the terms of the agreement on an annual basis. So the form that looks like is something we're going to have to flush out in the process. Interestingly, ONC has said if there's a data breach, they are going to impose specific timing requirements of 14 days, or 15 calendar days, 15 calendar days to notify of an information or a security breach. That flows up to the QHIN. QHINs then have to notify other QHINs within 7 days of that security incident occurring. We talked about the obligation to comply. And then finally, I just wanted to talk about, we talked about consent. Oh, if a QHIN receives a report of inaccurate or incomplete electronic PHI, then it has to remediate that and notify the participant that it has received incorrect information, and the participant then will have to remediate that as well. So within Michigan, we're going to hopefully have some simplified terms that become standard across all organizations so that participants and end users can have a similar set of terms that they have to manage contractually among the various participants with whom they are sharing information. And ultimately, it should streamline things and address a lot of the use cases that MyHIN's already looking at. Some are already in production, some yet to come. But that's going to be kind of the landscape within Michigan as TEFCA unrolls. And I think with that, we can take some questions, if there are any. None.
Stunned you into silence. Thank you.
How does TEFCA deal with the problem of variation of state laws and data that needs to go among parties in different states? Oh,
Question is, how does TEFCA deal with the problem of variation in state laws? It doesn't. It does not. TEFCA, again, TEFCA is a framework. It's not even a regulation. It's a guidance issued by ONC that proposes a exchange framework, and that will then be administered by the RCE and the QHINs and the HINs. It doesn't do anything to harmonize state law. Now, that question, Congress could have done that in Cures, and there was some discussion when we were working on the Cures language, when Lindsay and I were working on the Cures language, we had some discussion about shouldn't you go ahead and harmonize state law. And as you can imagine, that was just too toxic because that was perceived as stepping all over the states and having a mandate, and even with the prior administration, and this is not political, it's just simply a difference in philosophy, even with the prior administration and the prior Congress, that was a bridge too far. So no, we're left with the same jumble of laws that we have today.
Yeah, right here.
Thanks, Tim Pletcher from MyHIN. What's going to be an organization's motivation to actually have to do anything with TEFCA? I mean, are there any teeth that are going to make you have to sign up to a terms of service and a common agreement? What's the teeth behind all this?
Yeah, well, the first issue is that TEFCA is entirely voluntary. So they've said throughout the guidance right now that participation within TEFCA is entirely voluntary. I don't know if that's voluntary or voluntary. I don't know. What are your any?
Yeah, a couple of thoughts. CMS in I guess February, CMS published some interim guidance that suggests that they're going to take the position that participation in TEFCA is deemed, we'll give you some deemed status under Medicare in terms of entitlement to incentive payments. I'm working very hard to avoid meaningful use using that term, but and that came out under the the IPPS rules. So we all kind of woke up and said, well, holy cow, Medicare, this just became mandatory, and comments are due on that in a few weeks. I know that Sequoia will be putting in comments on that. So that would be the obvious one. And then the less obvious one would be around information blocking. A number of organizations, Sequoia and many others, suggested to ONC, it's like, look, okay, well, if you're going to go to all the trouble to do this, then why don't you, as a carrot, why don't you state that anyone that does voluntarily participate in the TEF will be deemed to not be information blocking, as long as they comply with the RCE's rules, essentially a safe harbor. And I don't have much hope that will happen, but a lot of people asked for it. So that would be, so we could have the stick from CMS, and we could have a carrot from from ONC and OIG, but right now we just don't know.
Yeah, over here.
Speak more about information blocking and what exactly that refers to.
Can we do it, or?
Sure.
Yeah. So Cures, so the Cures Act has a pretty simple sentence actually, where it says, information blocking is prohibited. And it's like, okay, well, what does that mean? And so then in that same section, and I can't call it up off the top of my head right now, sorry, but I can get it for you. It says that OIG and ONC will issue regulations to identify what is not information blocking. Now, that's really significant, because what that means is that's why I use the term whitelisting, because if your activity is not identified as permitted, then it is presumptively, illegal under TEFCA. And so we're all actually very worried about that. OIG, last summer, OIG and ONC went through a series of webinars and public meetings where they met with stakeholders. I participated in several of those, and we talked about, what are we doing now, we the industry, what are we doing now vis-a-vis information blocking and trying to overcome that. Care Quality talked about its non-discrimination provision and its trust agreement. Other people talked about the various approaches that they're taking. And they said, okay, thank you very much. And they sort of went back, and but that's when we were expecting a rule last fall. So now we're expecting a rule August, September. I don't know what it's going to say. If anyone does, it worries me, because I believe, my own view is that the rule is going to cast into question a lot of practices that are very commonplace in healthcare, and that people they're not trying to hoard information. There are some who are, but I just don't believe that that's the overall tenor of our industry right now in 2018. I just don't believe that. But I'm afraid that these rules are going to sort of take that approach. Like, you guys are hoarding data, and we're going to rein you in. I'm really worried about that. But I can't give you any more specifics than that.
Yeah, and just real quick, some examples that TEFCA gives additionally are data throttling, or TEFCA also takes a very dim view to proprietary technology and proprietary data formats, burdensome testing requirements. If you, as a QHIN, are imposing different testing requirements on a entity because of who their EHR vendor is than you would others. So they really look at unfair and unreasonable burdens that you might be putting on another participant in that same vein. But did you have a follow-up?
Just that for, I don't know if there are other provider systems here, but when we did our filings for meaningful use, or MIPS, this year, we had to attest that we were not information blocking, and I couldn't find a definition. So we said we weren't, but I didn't know what we said we weren't doing.
There's not a definition. That's right. Yeah. No, and that created a lot of angst among counsel, because it's like, well, what am I attesting to, or what are my principals attesting to? And I mean, and that's a perfect example. I mean, we're all veterans in this room with healthcare, so that's a perfect example of one agency being out in front of the other. That attestation, when it was written, it was supposed to be in the context of a final rule from OIG on information blocking, but we don't have that. So, yeah. Now, I think I'm not that worried about, you know, people being brought up on False Claims Act charges for that attestation. I just don't think that's going to happen realistically, but I get your concern. Hey, these are great questions.
All right, thank you.